Good morning, everyone. I can see people are joining, so welcome to our TUPE Club webinar. This is the first one for this year, and what we've got planned today is a back to basics session looking at all the key ingredients of TUPE. So it's for those of you who've perhaps not come across TUPE before, or if you've not had a refresher recently, or if there's something coming down the tracks that you want to brush up your skills for, this should be an ideal session for you. I'm Siobhan Bishop, a Principal Associate at Gowling WLG, and I'm joined today by Jane Fielding, who's a partner in our team, and also Hannah Swindle, who's a Principal Associate in our team. And you'll see KJ is with us for technical support. So both of our speakers today have a wealth of experience in everyday TUPE and extremely complicated TUPE. So even though we've built it as a back to basics, rest assured you will be getting some key tips and guidance on how to deal with the difficulties of TUPE on the ground and in certain situations to make sure that you're dealing with commercial realities and your TUPE transfer goes well. So looking at the agenda today. The first thing we'll look at is what is the effect of TUPE of the employees and the employer, because there are implications on both sides with extra protections from employees and also therefore extra risks for the employers. Then we'll move on to the when TUPE applies. Now this is a fundamental question, of course, and it is quite complicated in itself. Then the next matter will be information and consultation, which is one of the key practical things that you need to do in a TUPE scenario. And you need to deal with that on the ground, and that can be quite difficult to apply the theory to the reality. Then the last section, we'll bring it all together and we'll look at mitigating the risks. So identifying those risks and potential ways of solving them and limiting any liability that you might face. And at the end, we will have time for questions. So please do feel free to submit your questions on the Q&A button. And you don't need to wait till the end. You can submit them at any time and we'll pick them up as we go through. So we'll answer as many as we can at the end. But in the meantime, I think I will pass you over now to Jane Fielding to deal with the first topic.
So first of all, what is TUPE? Well, if you remember nothing else about this talk, apart from the technical lapse, which hopefully you'll have forgotten by the end, the transfer of undertakings, protection of employment regulations, remember the bit in brackets, because if you're faced with a TUPE situation and you're not quite sure how things will play out, remember it's about protecting employees. And it's about protecting employees in situations where either the business that they work in is sold as an asset transfer, or where the services that they're working in are provided by a different provider going forward. So a sort of outsourcing or insourcing situation, which Hannah will come on to look at. So where does it come from? Well, it comes from Europe, which will be important, as we'll see in a minute. And it was the Acquired Rights Directive in 1977 that brought it in. We first started grappling with it in the UK in 1981, as you can see. It was overhauled in 2006. And again, we had some changes in 2014, but the underlying regulations that we use are still the 2006 ones. And then, of course, on top of all of that, we've got a plethora of case law, both domestic and at European level, that we have to deal with as an overlay to the regulations. Now, although they're quite short, they are in fact quite fiddly because of all of that. And we also, as I mentioned, they come from Europe. So we need to think about, well, what's the situation now post-Brexit? So we'll turn to that next. If whoever's controlling the slides could click it on for me, please. Thank you. So currently, this is the position. So you'll all remember the withdrawal agreement, the EU Withdrawal Act from 2018, set this implementation period for the 31st of December 2020. And what the effect of that was that we had this concept of retained EU law, and everything that was in place as EU law prior to the implementation period completion date was frozen as part of our law. And basically it gave EU law and decisions the same status as Supreme Court decisions in this country. And there is rather, a right for certain courts to depart from those EU cases if they consider it right to do so. And those courts are the Supreme Court, of course, but also the Court of Appeal and the Court of Session in Scotland. Below that, people still have to abide by it. So for TUPE purposes, most cases, because it doesn't generate quite as much case law as discrimination, for example, or unfair dismissal, most cases only get to the Employment Appeal Tribunal, which is the one below the Court of Appeal. So they will have to follow European case law still. Now, we'll have to wait and see how long it is before a court does depart from EU case law, but in any event, it might all be about to change anyway, which I'll come on to in a minute. But if we could click on, I've just dealt with what happened in terms of case law that was already, law and case law that was already part of our domestic law derived from Europe before the implementation period. What about things currently that come in after that? Well, our courts aren't bound by any decisions of the European Court of Justice after implementation period, or by the principles or the cases, but they can have regard to them if it's appropriate for them to do so in their view. But, and this is the perhaps more current bit, what next? So the government at the moment is grappling with this retained EU law revocation and reform bill, which they're trying to get through at the moment. And this is where they're working to this sunset date of the 31st of December this year. And the effect of the bill, if it's passed, is twofold. So all EU-derived secondary legislation and that retained direct EU law that we were just looking at, that direct legislation, that will expire automatically at the end of this year, unless one of two things happens. The first is that it's expressly retained by a specific piece of legislation that's passed before then, or a minister can extend that review period up to the end of 2026, just if they need more time to look at it. And the second effect is that it will end the supremacy of EU law. So courts will be able to depart from it if they see fit. So it will introduce that level of uncertainty when we're getting challenges in the tribunal in the case of TUPE. So we don't know at the moment what the government is planning to do around TUPE, but clearly it's been up for discussion in the past several times, even before Brexit. And so the sort of likely areas, if the government was looking to weaken protection, perhaps make us more competitive, make it cheaper to employ people or easier, have more flexibility, are the four that we've put on the slide. So potentially they might make more strict the definition of who is caught by TUPE, change it from workers to pure employees. They might make consultation information a bit easier, or relax the rules on harmonising terms and conditions after a TUPE transfer, which we'll come on to see is quite tricky, or around replicating benefits. So the transferee having to put in place the same or substantially similar benefits to the transferor. So we don't know yet, but the government will need to be a bit careful with this because there is this non-regression principle that's built into the trade and cooperation agreement between the UK and the EU, which was part of leaving Europe. And where UK, in this case, changes TUPE, for example, and that impacts or affects trade or investment, then there's a dispute resolution mechanism which the EU might trigger, because they would be saying, you know, well, you've watered this down and it's given people a competitive advantage doing business in the UK compared to Europe. So it remains to be seen, but for now, obviously, TUPE is as we are about to explain it, but watch this space. So if we move on to the effects of TUPE, the first one, and remember it's all about protecting employees and particularly assigned employees who are assigned to the business or service that's transferring. And Hannah is going to look at assignment in a bit more detail. But in summary, the three main sort of effects are that assigned employees move across with the work they're doing to the new employer. They do, though, have a right to object to that. So again, protection of employment, it's a fundamental principle of TUPE and it's built in with the right to opt out. You can't be forced to work for an organisation you don't want to work for. They move over on their existing terms and conditions. and there are a couple of exceptions to this, which we'll come on to, but basically they move over as they are. In terms of collective issues, if you're dealing with a unionized workplace, if there are terms and conditions in the employment contracts that have flowed down from a collective agreement between the transferor and the union, then the new employer will inherit those as at the point of transfer, so as agreed at the point of the transfer. So if there's a 3-year pay deal agreed and you're in year 1, then the new employer will inherit the remaining period of that agreement. So the next 2 years, the pay increases they'll have to honour. And in terms of, if we could just go back a minute, please, in terms of union recognition, that can also transfer. So as long as the bargaining unit retains a distinct identity in the transferee's organisation, then that could transfer, but it transfers on the same basis as the transferor had it. So if it's voluntary recognition, then the transferee could de-recognise, albeit bearing in mind the industrial relations issues around that. Claims also transfer that are alive at the point of the transfer. So if somebody's got an unpaid wages claim, a harassment, grievance, anything like that, the transferee will step into the shoes of the transferor. So if we move on, I'll just pick up those exceptions. So unlike civil or tortious liabilities, criminal liabilities don't transfer. So the transferor retains those if they exist. So in a TUPE context, it could be something around immigration checks, could be criminal liabilities under tax. But the more significant exception is the pension exception. So if you have an occupational pension scheme, or the transferor does, then the old age benefits under that scheme do not transfer to the transferee. However, and that's why the but is in capital letters, any early retirement or enhanced redundancy benefits under that pension scheme will transfer. And those can be potentially very expensive and also hard to value and identify. So they're what's called the Beckman and Martin rights, which you may have heard of. Now, if that comes up, we have an excellent pensions team who we always call on in this scenario to help out, because those, as I say, those liabilities can be very substantial, and it's really important to know what they are and where they're going to fall. Private pensions also transfer. So if the transferor has committed to make a contractual contribution of 10% of salary into a private pension, then that will transfer as well, and the transferee will have to fund it. So looking at a few more effects of TUPE, as I explained earlier, changing people transfer on their existing terms and conditions, and in a TUPE context, it's more difficult than it would normally be to change those terms. Now, there can be some flexibility in the contract which the transferee inherits, but you always have to approach that with caution. And even with consent of the employee in question in a TUPE transfer, changing terms and conditions is very tricky. And if it's not done validly, then they are completely void. So that's a big topic in itself, which we're not going to touch today, but just to flag, it is a tricky area to take advice on and look at the time. The second protection, which is very important, is unfair dismissal. So employees still need 2-year qualifying period for this. But if they can show that the sole or principal reason for the dismissal was the transfer, then it's an automatic unfair dismissal, which means basically you can follow as good a process as you like in terms of consulting and explaining what you're doing. But if they make out that link, it's an automatic unfair dismissal. Now, it can be saved from being automatically unfair if you actually can show you had an economic, technical, or organizational reason for the dismissal, which involves a change in the workforce. And that's either a change in the headcount, so reduction in numbers, or a geographical relocation. And if you have that, it's not automatically unfair, but you look back at normal unfair dismissal principles. So that's a pretty valuable protection. And then the last major protection that the staff have are information and consultation obligations. So there's an obligation around the transferor providing employee information to the transferee, and then there are information and consultation obligations for potentially both the transferor and the transferee to consult with representatives of affected employees. And that area I'm going to look at in a little bit more detail later. But for now, I will hand over to Hannah, who's going to talk about when TUPE applies.
Thank you, Jane. Okay, so I'm going to look at the question of when does TUPE apply, which is always the million-dollar question. We spend a lot of time helping clients to identify the risks of TUPE applying, but we're never going to get 100% certainty of that. So sometimes we just have to take a view and proceed on the basis of whether it will or not. To be able to get to as certain a position as we can, we need to look at the legal framework. So on the slide, we've got the initial question there that we're going to be looking at. TUPE applies where there is a relevant transfer, and there are two types of potential transfer. First of all, we have a business transfer, and the classic example of that is where you've got an entire business being sold as a going concern. The other type is a service provision change, which involves outsourcing and a change in the provider of services to a client. The two types of transfer do overlap. It can be both at the same time, so we've always got to consider both of them when we're looking at this question. So if we move on to the next slide then, we'll look first at the business transfer. It's often called an old style transfer because it's been with us since TUPE first came about in the UK in 1981. For this type of transfer, we need to have a transfer of an economic entity or undertaking, or part of one, in the UK, and it's transferring to another legal person or company. So as we can see from the diagram on the slide, the transfer of employees will be from the seller or the transferor going to the buyer or the transferee. So if we look at this in a bit more detail on the next slide, please. So first of all, for TUPE to apply, we need to have an undertaking or a business or part of an undertaking or business. It's got to be in the UK, and there has to be a transfer of the running of that business or part of one to another legal person, usually another company. The economic entity or undertaking also needs to retain its identity. It's got to keep its identity after the transfer, and I'll come on to that in a moment. Often in a business transfer, there's going to be a written purchase or sale agreement or contract. But importantly, there's no need for a contract between the two parties for TUPE to apply. The important thing is to look at the start and end point of where the work or the business is moving to and from to identify whether you've actually got a transfer taking place. Just to add a note here, TUPE doesn't apply to the sale of shares. But confusingly, there is the potential for it to apply before or after a share sale, because if you've got any sort of intra-group reorganisation, moving parts of the business around before or after that sale, then it could apply then. So looking at economic entity then, what is that? According to the TUPE regulations, it's an organised grouping of resources pursuing an economic activity. So absolutely clear. It doesn't matter whether that economic activity is central to the business or just ancillary or part of it, but you need to be able to identify it. It's still quite confusing, I think, as to what this actually means in practice. But what we do know is that it's not just a collection of assets. So when does it tip over then into something more than just a transfer of assets? Where you've got a whole division of a business being sold, then I think it's quite clear really, or even more obviously, if you've got the sale of all of the assets of an entire business to a single buyer. Where you've got more than one buyer for the assets of a company, then I think it becomes more difficult to work out, and you need to look at each split in detail. You need to ask the question of whether there's enough for what's being sold for it to be an economic entity. And that might depend on what asset is included in the sale and its importance based on the nature of the business. So what do I mean by that? Well, for example, in a software business, the focus might be the IP, the intellectual property rights. In a cleaning business, the people carrying out the cleaning are usually the most important asset, the main asset. So we would then ask, well, where are the people going? For TUPE to apply, that undertaking or economic entity has to keep its identity after the transfer for TUPE to apply. The test that's used to work this out is often called the going concern test. All relevant factors need to be looked at, including what has actually transferred. So that might include the goodwill of the business and what's included in terms of the assets. And as I've mentioned, the transfer of certain assets is going to carry more weight and be more important for different types of businesses. You'll also need to look at how similar the activities carried on by the business are before and after the transfer, and whether there's also a transfer of employees and customers. And finally, we know from case law that an entity can retain its identity even if it's integrated into the transferee's business after the transfer and doesn't have its own sort of autonomous organisational structure going forward. So if we move on to the second type of transfer then, the second test in TUPE, the second relevant transfer, is one that came about in 2006. And that was largely to address the fact that the old style test had started being applied through case law to outsourcing situations. So the service provision change test was brought in to try to give a bit more certainty as to when it might apply in outsourcing situations. And it's going to apply in three scenarios. The first is where you've got an outsourcing of services by a client to a contractor. They don't want to do the services themselves anymore. They're carrying out the activities on their own behalf. They bring in a contractor to do those for them. The second scenario is where a client has decided that it wants to switch to a different supplier or service provider. And that's sometimes called a second generation outsourcing. You're transferring activities or services from one contractor to another. And then finally, it can apply to an insourcing. So activities or services that were previously provided by a contractor, the client decides they now want to take that activity, those services back in-house and do them themselves. So the next slide shows the typical model in an outsourcing service provision change situation. You've got the customer for the services at the top. Then at the next level down, we've got the service provider or the suppliers, and they're going to be the outgoing and the incoming employers. Where there's a change in service provider, the TUPE transfer of the employees goes directly from the outgoing supplier to the incoming supplier. But there's no direct contract between these two suppliers. And so TUPE works independently from the actual contracts which sit between the supplier and the customer. And the customer itself is not a party to that TUPE transfer. This is really important because it impacts on how any indemnities contained in the contract and how those protections work. We normally include indemnities in a contract where TUPE applies because we want to protect the incoming employer from inheriting employee liabilities which occur because of the actions of the outgoing employer. Because otherwise, as Jane has mentioned, because of that automatic transfer principle of TUPE, all of those existing potential claims and liabilities transfer over automatically with the employees. So in a business sale, we have contractual protections going directly between the outgoing and the incoming employer. But here, we don't have that direct contract. So they'll be between each supplier and the customer. And the customer then needs to pass through those indemnity protections received from each supplier to the other under its existing and future contracts for services. So if we move on and look at the conditions for a service provision change in a bit more detail then. So you need an organised grouping of employees situated in Great Britain. So an organised group. And their principal purpose needs to be the carrying out of activities on behalf of the client. They've got to be deliberately organised to carry out those tasks. It's not enough that you might have a group of employees who end up mainly working on activities for one client by happenstance, a term we've had from case law, such as, for example, because of the particular shifts they tend to work. It's also necessary that the client intends that fundamentally the same activities will continue after the transfer. And whether those activities are fundamentally the same is a question of fact that ultimately would be decided by a tribunal if there was a dispute. But looking at whether activities are going to be fundamentally the same, the parties need to look at how the activities are carried out in practice, but also what the contract says, how they're described under the contract. There are a couple of key exceptions to be aware of. They've been written into the TUPE regulations. A service provision change doesn't apply to contracts wholly or mainly for the supply of goods for the client's own use. So we've had some guidance from the government on what that means. And they give the example of a contract to supply sandwiches for a client to sell to staff in its canteen. That's going to be covered by the exemption. So TUPE won't apply if they change that contract or retender it. But you can contrast that with a contract to run the staff canteen, where the activities are not going to be wholly or mainly for the supply of goods. It's a service, so TUPE would potentially apply there. The second exemption is that it will not apply to contracts for a single specific task or event of short-term duration. Case law has confirmed for us that the two terms should be read together. So we're actually referring to a single specific event of short-term duration. So again, looking at the government guidance as to what they mean by that, they've given us an example, which is the supply of security services at the Olympic Games. Working out whether this exemption would apply with any degree of certainty is very difficult in practice. What would be considered short-term is always a question of fact and degree. And you also need to look at what the client's intention immediately before the transfer. That's also really important. What is clear is that you can't use the exemption to get around TUPE just by entering into a succession of one-day cleaning contracts, for example, because there the client really intends the service to continue on a longer-term basis. But I think it's fair to say, because of all the certainty around this exemption and when it will apply, quite often we don't rely on it in practice. So moving on now to the question of assignment. So we worked out that we do have a TUPE transfer situation. So next, we need to consider who is it going to apply to. TUPE regulations state that TUPE applies to all employees assigned to the organised grouping or undertaking that is transferring. They helpfully don't define assignment in the regulations. All they state is it's other than on a temporary basis. So assignment is really going to be a question of fact in any one case. And to try and work out what assignment means, we're looking to case law. And that's confirmed that it's important to look at a number of different factors to try and work this out. None of the factors which were set out on the slide there, none of them are determinative in and of themselves. You've got to look at them all together, try and get that big picture. At the top of the slide there, we've got time. We're often asked whether someone will be assigned for TUPE purposes if they work more than 50% in the business or on particular services. It's a useful starting point, a good rule of thumb, to identify the people who are most likely to be in scope. But importantly, it's not simply just a question of how much time they spend on that particular business or service. It is a factor, but it's not determinative. We also need to look at things like the nature of the work. What do they do in practice? What does it say in their employment contract about the tasks and duties they are contracted to do? And also, importantly, what are their actual day-to-day responsibilities? Allocation of costs can also be relevant. Where you've got the provision of services, is the cost of an employee allocated to a particular client or customer contract, for example? We also need to look at the value of that individual for the service or the business in question. But what we do know is that someone has got to be assigned other than on a temporary basis. So to put some colour on that, TUPE is not going to apply to a temporary secondee into a service or part of a business. but it would apply to someone who's made a permanent transfer, even if that's been carried out relatively recently. The trickier areas often come about where employees work on more than one contract or for more than one client. For example, you might have an employee such as a project manager, or possibly in a shared service team such as HR or IT, which supports many parts of the business. In those cases, it's really important to look at all those factors, including the type of job. A project manager is not going to be necessarily assigned to a contract just because they're spending all of their time on that contract in the lead up to the transfer because they're carrying out some troubleshooting. It can also be the case eventually that employees are not actually assigned to any particular contract. Thank you. I'll pass you back to Jane now.
Thanks, Hannah. So I'm going to pick up on information and consultation now. So I mentioned earlier there are the two aspects of it. There's the information the transferor gives to the transferee to help them understand who and what they're inheriting. So that's the employee liability information. And we've summarised on the screen there the detail of that, which is in Regulation 11. Obviously, there's a bit more detail in Regulation 11. And if you need to pull this information together, you need to be having a look at that. I'm not going to go through it because you can see what it is there. But what you can see at a glance is, particularly if you've got a lot of people in scope to transfer, then there's going to be a degree of organisation and coordination needed at the transferor's end to pull that all together. So you need to be geared up to do that. And in our experience, HR teams who are very experienced at this have quite a slick system. Others struggle a bit more to get the information together in time. So if we move on, what does the transferor do with that information once gathered? Well, they have to provide it to the transferee at least 28 days before the transfer or the date when they expect the transfer to happen. Now, if you do that in compliance with Regulation 11, you don't have to worry about anonymising it because complying with that statutory regulation gives you your defence under data protection law to revealing the identity of individuals. If you don't do that as a transferor, you're potentially on the hook for compensation to the transferee if they claim in the employment tribunal. And that is a minimum of £500 per employee for whom you don't provide the information. Although point 4 on the slide there does indicate that if there's a contract in place around provision of information and there are indemnities in there, then the tribunal will have regard to where the parties wanted that apportionment to go. So they will have regard to that if there is a contract with relevant indemnities in it. The point I really wanted to focus on here is point 3 and why I say this is too little, too late, getting it 28 days before the transfer. So why is it too little? Well, if you look at Regulation 11 and the previous slide, when you get a moment, you'll see that there are some key things missing from there that you would probably want to know about if you were a transferee. So, for example, if you were looking at a headcount reduction after the transfer, you would want to know if there were any enhanced redundancy entitlements that you were going to be inheriting, and that isn't part of Regulation 11. If in a business protection situation, a business sale situation in particular, you might be concerned about restricted covenants from a business protection perspective, and Regulation 11 wouldn't give you that either. So we often see in an outsourcing situation, these information provisions supplemented by contractual provisions where the customer has built into the contract a requirement that the outgoing service provider or potential outgoing service provider in a tender situation has to provide information that is more useful so that that can help people shape their bids and price for the contract. Those sorts of provisions will also usually address the second point about why it's too late. They will usually require that information to be given on request or certainly earlier in the process than 28 days, so that again that can help shape the transfer and the bids that people are putting in response to the tender. So if we move on to the second aspect of information and consultation, and this is the one that sort of most obviously helps, or more obviously helps, the staff who are affected, and this is the obligation to inform and consult with them but it's via appropriate representatives. So before we get on to what that means, I just wanted to flag that information and consultation are two separate obligations. The obligation to inform will be present in every TUPE situation, but under TUPE, the obligation to consult as a mandatory step is only present if the employer envisages measures. And we'll come on to look at what measures mean shortly. But even if there are no measures, then what case law has told us, building on TUPE, is that you have to leave time in the timetable of the deal for voluntary consultation. So staff and their reps have an opportunity to ask questions and see what's going on. So there are two key points here. Firstly, this obligation to inform and consult does not just apply to the in-scope staff. It applies to anyone affected by the transfer. So it could be that the transferor, once it loses the people who are going to go over to the transferee, doesn't need as many head office staff because there aren't as many other staff to support. They might therefore be affected because they're going to be put through a redundancy process. So it's wider, and if you miss that point, then you risk not fully complying, and there's a penalty for that, which we'll come on to look at. So looking at who are appropriate representatives, well, if you've got a trade union that's recognised in respect of the whole workforce, the whole affected employees, then they are the appropriate representative and you have to consult with them. If you don't have a union at all, or you do have one, but it doesn't, the recognition doesn't cover all of the people who are affected, then you, as the employer, have to look at putting different employee representatives in place as the appropriate representative. And you have a choice there, potentially. If you have a pre-elected staff forum and the remit of that forum is sufficient to cover TUPE, then you might choose to use that forum. Or you could invite the affected staff to elect representatives specifically for the particular TUPE transfer. And we usually see people prefer to do the latter because it avoids any question about whether the staff body that you're going to use, the pre-existing staff body, has the right remit overall, and whether individual members of that body are still within their term of office, or whether there might be a problem there. But if you are going to invite an election, then obviously you need to factor time for that into the timetable, which can affect how long it all takes. So what do you actually have to tell them when you inform them? If we move on to the next slide, we've set that out. Basically, it's telling the staff, what's going to happen to them, why, and giving them information about the measures that the transferor or the transferee envisage. And if there are no measures, confirmation of that. So you have to give this in writing, but otherwise it's sort of fairly unprescriptive about how you do it under TUPE. But it's the what's going to happen, why, and who is it going to happen to. I wanted to look more closely at the last two things on this slide. So measures, because that's really critical. And it's measures envisaged in the case of the transferor staff by the transferor and the transferee. And it also begs the question, of course, what do we mean by measures? Now, we've already had a couple of phrases come up and say, well, TUPE doesn't have a definition of that. And again, TUPE is unhelpful in not having a definition, but what case law tells us is it's any positive act or omission by the employer in question. And it's also been borne out many times in case law that that is a pretty low threshold, indeed a very low threshold. So in one case, there was a change in the payroll date, which meant people's deductions were very slightly affected, to the matter of pence in some cases. And in some cases, the change was to their benefit, not their detriment. That was still found to be a measure. So it's a low threshold. Now, in terms of agency workers, this is slightly odd in a TUPE context, but part of the information has to be how many agency workers are employed in the whole business, not just the little bit that's transferring if it's a partial transfer, what they do, and which parts of the business they are in. So there's a parallel obligation in the collective redundancy legislation, which kind of makes more sense, because in that case, the representatives might be saying, well, before you look to reduce employee headcount, why don't you terminate the agency workers first? Doesn't really fit that well with TUPE, but it is there. And there are cases where people have been subject to a penalty where they haven't provided that. So if we move on to the duty to consult, again, all TUPE says is you have to do it long enough before the transfer to enable meaningful consultation to take place, which really translates into saying you've got to do it in good time for it to be an effective process. And that's obviously going to depend on how many people you've got involved and the extent of the measures that you're proposing. Now, there is a slight oddity I wanted to flag here on measures. The under TUPE itself, there isn't an obligation on the transferor to consult with its employees, so the ones that are, including the ones that are going to be moving across, not just all the affected ones, on the transferee's measures. So the transferee has to tell the transferor what measures it's proposing, or if there aren't any, that there aren't any. But the transferor isn't then under an obligation to do more than pass that on to the appropriate representatives. In practice, what happens, because generally people want to try and make it as smooth a process as possible, they will do that, or they'll invite the transferee in to talk to the staff directly in their presence, but it's not actually an obligation under TUPE. And of course, the flip side as well is sometimes where the transferee's staff are affected by all these new staff coming in, that bit of consultation is forgotten as well. If the transferee is potentially going to have to make redundancies, sometimes consulting with their own existing staff can be overlooked. So in terms of the penalty, it's 13 weeks gross pay per employee affected by whatever the level of default is for failing to do this properly. So a good shorthand for that, which we often use to get the attention of the finance director, for example, is it's a quarter of the annual wage bill of the staff affected. Now that's the maximum, and that's what you're going to face if you do nothing. But if you can do something, and you do something, then you have the opportunity to argue that penalty down to something, in some cases, considerably lower if it's a really sort of minor or technical breach. Now, we quite often get asked, well, is there a defence to that? We're getting, a lot of pressure from our parent company abroad who don't understand TUPE, or we're in an insolvency situation. Do we really have to do this? And our advice generally is, well, there is a special circumstances defence, but it's almost never applicable. So really try and do whatever you can in the time available with whatever information you've got as a way to mitigate the risk of that quite heavy penalty potentially. So that's a good point to hand over to Hannah, who's going to talk more about mitigating risks.
Thanks, Jane. So yes, the automatic transfer principle of TUPE and the additional obligations that it places on both the outgoing and incoming employer can result in some potentially significant additional risk and costs. So first of all then, the parties need to know who's going to transfer. If you're the incoming employer, it's important to try to obtain information about who you're going to inherit. You may need to know that you're going to have enough staff and also any key employees with the correct knowledge to be up and running with the services from day one. If you don't inherit the correct employees, that could impact on your ability to meet service requirements for your customer. You also need to be aware if anyone is temporarily out of the business, for example, on sick leave or family leave, because they're still assigned, they will still transfer. If you're the outgoing employer, you also need to know what your remaining workforce is going to look like after the transfer. It's less of a problem if you've got an entire service being outsourced or moved to another provider, and it's clear which employees work on those services and so are going to transfer with it, and the same for a business sale. But it's more difficult where you've only got part of the service or business transferring, but you've got employees working across the entire service or business. You also need to check whether you're going to lose any key employees yourself. If you are, and you want to make sure they're going to be retained, you'll need to think about ways to do that in good time. So, for example, you might want to move them into other parts of the business before the transfer to take them out of the scope of it. The next point on the slide is more of a problem for the incoming employer. We've heard the employees transfer across with all of their pre-existing rights and liabilities, with a few exceptions. The incoming employer's got to work out how to replicate the benefits that employees are entitled to. Can often be a problem, especially where you've got insurance type benefits or where those benefits are linked to the outgoing employer's business, such as access to a share option scheme, for example. There might also be some pre-existing issues in the transferring workforce that you're going to have to deal with. There might be some long-term sickness absence or ongoing disciplinary issues. The next point is information and consultation that James just talked about. As we've heard, the potential maximum liability is a quarter of the wage bill, 13 weeks gross pay if you get it wrong. So it's very important to build in sufficient time to make sure you do a proper process. And then there might be some deal-specific risks because of the particular transaction. So, for example, the transferring employees may have generous pension benefits, some of these Beckman and Martin liabilities we've heard about. Or there might be the need for a lot of redundancies at the start to right-size the service. And I'll come on to how we might deal with those in a moment. So other examples of risks, if we move on to the next slide, please. Other example of risks that might arise are where the incoming employer wants to make some changes to terms and conditions of employment or working conditions. They might need the incoming workforce to fit in with existing shift patterns, for example. It's important to remember that any proposed change is going to be a measure for the purposes of that information and consultation process. And all measures need to be consulted about, even if they don't consist of a contractual change. Jane mentioned the additional protections that TUPE gives employees around changing terms and conditions. There might be issues ensuring that any contractual changes put in place are valid. As Jane mentioned, this is quite a tricky situation. It needs to be considered and thought about carefully. We often have redundancy situations arising in connection with the transfer that we've touched on. It might be the case that the incoming employer's got too many employees after the transfer because of that automatic transfer principle. They may also operate from a different location, and they might not be able to make the staff relocate because of the terms of the contract, or the staff just may not want to. The outgoing employer might also have a potential redundancy situation in its retained population because it doesn't need as many staff after losing contracts that the employees worked across, for example. So all of those cases, wherever the redundancy situation arises, any dismissals have got to be carried out fairly, or you've got the risk of claims. But again, if you've got post-transfer redundancies, they're going to be a measure that need to be introduced as part of the consultation process. Where there's an outsourcing situation, we've got an added level of complexity. I've talked about that there's going to be 3 parties involved, but you've only got the transfer taking place between the outgoing and incoming suppliers. And where you've got that transfer happening at that level, but only one of them is going to be party to the contract, to a contract with the customer at any one time. So outsourcing brings its own challenges because of that tripartite nature of the arrangement. And where you have a change in provider, the incoming employer doesn't have any direct indemnity protection from the outgoing employer, as you might have in a business sale. So that means that all indemnities have to be flowed through the customer. As the customer enters into a new contract with the incoming supplier, it needs to think about what indemnity protection rights it currently has under its existing contract with the outgoing supplier to know what it has to be able to pass on. It's most likely going to be the case that the incoming supplier is going to ask for that indemnity protection from the customer. They want indemnities to cover pre-transfer liabilities connected with those transferring employees. And if the customer doesn't have suitable protections in its existing contract with the outgoing provider, is going to be left exposed if it then gives them in its incoming contract. The incoming supplier has got to account for the risk of any problems it inherits automatically under TUPE. So if it doesn't get those indemnity protections, it might then have to increase its charges or protections to factor those in. So these are all issues that a customer will have to consider. So some further points on outsourcing then. The customer has got to flow through to a new supplier any obligations it might be subject to under its existing contract with the outgoing supplier that might relate to those transferring employees. The customer is going to have to make sure that the new supplier, as the incoming employer, complies with them, because otherwise the customer is left on the hook to the outgoing supplier and could be responsible for any potential liabilities that the incoming employer causes. It's important not to forget about subcontractors. If a supplier is using them to supply the services, then this needs to be taken into account when you're drafting any contract for services. You might be placing obligations on the supplier. You might give them rights or ask them for protections in respect of all the staff working on the contract, not just their own employees. So if there's anything that's going to apply to the workforce as a whole, all of those rights and obligations need to be flowed down into the subcontract. The customer's also got to think about how employees are going to be managed during the contract. It's usually going to want to place some controls on the supplier. In particular, it's thinking about whether there may be a transfer on exit to a new supplier coming in. So it's going to want to stop the supplier being able to do anything which might cause a problem for that new supplier because of the automatic transfer principle of TUPE. So, for example, they might want to prevent a supplier moving well-performing staff off the contract and moving poor performers on when we're coming up to termination, or maybe materially changing terms and conditions to the employee's benefit. And these types of provisions are often called anti-sabotage controls for obvious reasons. The customer also needs to include the right to ask for information at an appropriate time, needs to be able to complete its retendering processes effectively and know who might be in scope to transfer. Jane talked about ELI information, employee liability information, but that's very limited in terms of content, often provided too late. So under the contract, you can use that to require the supplier to provide more employee information and at an earlier stage. Finally, parties in negotiations often concentrate on the start of a contract. They want to get things up and running, but forget to think about exit. It's really important to try and think about what might happen at the end. Do we expect TUPE to apply? If we do, we're going to need the usual indemnity protections. And if you're a supplier, what are you going to do if TUPE doesn't apply? Would you be looking to ask the customer to cover any redundancy costs, for example? This might be more of an issue if you've taken on a lot of people at the start of a contract, so you don't want to be left carrying the cost for them at the end. And even if the parties don't expect TUPE to apply at the outset of a contract, the customer needs to make sure that it's got adequate indemnity protections in place, because the supplier could change how it organises those services and uses its employees during the term, which could mean that TUPE applies at the end after all. So a few reminders then. Where there are people carrying out services or working in a business, you've always got to consider TUPE, even if you don't think it's going to apply. Sorry, can we move on to the next slide, please, KJ? Thank you. It's much better to address any potential issues at the start rather than being tied into a position later during contract negotiation. It's really, really important to carry out due diligence, to look at who's working in connection with the business or services. Don't forget subcontractors. As I've said, there could be subcontractors working on the services as well. Are there any risks or liabilities connected with them? Is there anyone on long-term sick, any potential claims lurking around? Ideally, you want to know about these issues before the transfer, even though it's not going to stop the individuals themselves transferring. In some cases, you might be able to agree that the seller or the customer will take responsibility for any potential liabilities, or to ensure that the outgoing employer actually agrees to cooperate with any ongoing disciplinary issue, for example. Workforce planning is really important for both the incoming and the outgoing employer. Who are you going to inherit Who are you going to be left with? Are you still going to have the key employees that you need? So moving on to the next slide then. To do that workforce planning, you need to factor in enough time, carry out the due diligence and the planning processes. You need to consider TUPE at an early enough stage so they can be dealt with. If you're going to run an information and consultation process properly, that needs time. You might need to elect reps and to allow some time to do that. If one party doesn't want to carry out that full process, for example, because of confidentiality in a deal, maybe consider whether they should be bearing any financial risk of not doing so. Also, keep a document trail of any communications to staff and minutes from meetings. These will help if there's any later dispute. You might need redundancies to make the business or services the right size. Who's going to pay? If you're doing them for a customer, they may carry the cost. The timing is important. Often the parties want to do the redundancies pre-transfer, especially where there's a relocation to a different site, because it saves time and cost post-transfer. But because of the increased protections around TUPE, there are greater risks of doing that beforehand. So you have to weigh up the risk of doing the redundancies sooner with the increased financial risk. It might be better to wait until afterwards. Sometimes you can use a settlement agreement to compromise any unfair dismissal claims. That will have their own costs because the employees need to take legal advice and you have to pay the employees an ex gratia amount, but it might be worth it if you need those dismissals to take place without risk on the day of the transfer. So finally then, another way of mitigating risks, I've spoken about them all the way along. Sorry, next slide, please, KJ, is to get the contractual protection. This is really key when you're entering into any sort of agreement for services. The customer needs to be able to require the supplier to provide employee information at an early stage, and you can use warranties to ensure that the outgoing employer stands behind the accuracy and the completeness of that information provided. Indemnities are really key in the context of a TUPE transfer. You use them as standard market practice to apportion those liabilities before and after the transfer and deal with any costs that might come up because parties don't, for example, comply with their obligations to inform and consult. You could also use them to cover any specific risks, long-term sickness absence, or any ongoing claim that might exist there. Importantly, if there's any significant pension liabilities, you really need to consider that indemnity protection, and that might be more likely where you've had employees coming originally from the public sector. So the final point I just want to get everyone to take away today is that the commercial drivers are always key. Employee risks might not be the most important factor. If you've got the need for a particular deal to happen really quickly, then the employment aspects may be secondary. But if the employee issues are considered early on, then you can take a decision how to progress and take things forward, taking into account the costs of any employee risks. So I know we have come up to time. I don't know whether we've got some time to take any questions, whether we can deal with those afterwards.
So if you need to leave, please feel free to do so, but we will take some questions as we promised to do so. So we've had quite a few in. Thanks to Hannah, thanks to Jane, and thank you for those who have submitted the questions. I'll move straight to the first question to Jane. So this is a question about someone who is a supplier and how can they contract out of TUPE as much as possible?
Okay, well, you can't agree to contract out of TUPE as between a contractor and a customer, or as between two businesses. If you're in a business sale transfer, what you have to do is all the things that Hannah was just talking about, which is to make sure that you understand where everybody has agreed the liabilities should lie, and make sure the contract reflects that. So, for example, if in a business sale, the timetable is being driven by the buyer and they want to do it all in a hurry and there isn't time to do a proper information and consultation exercise, then the seller should be in a reasonably strong commercial position, or other things being equal, to say, well, then if there's a penalty for that, then you should bear the cost of that because you're the one pushing for it. So it's about apportioning the liabilities in the contract rather than contracting out per se. Okay, thank you. Hannah, we've got two quick questions for you. So the first one,
is about TUPE applying where there is a transfer of the entire assets of a company instead of the shares. Is that a case where TUPE would apply?
Yes, absolutely. So we're saying that TUPE doesn't apply to share sales. There can be connected transfers if you've got reorganization of the business before or after that share sale, but TUPE doesn't apply. But where you are, you have a situation where the entire business of a company is being bought, then yes, that is a classic situation where you would have a business transfer type TUPE transfer.
Okay, and what about where the transfer is going to take place? So do transfers have to be from a UK company to another UK company?
This is slightly more of a tricky situation that would need to be considered how you're going to deal with it at the time. But in essence, just because you have an incoming employer that's not based in the UK doesn't mean that you wouldn't necessarily have all the recipe, all the conditions satisfied for TUPE in the outgoing employer. So as I mentioned at the start, for TUPE to apply, you do have to have an undertaking where you've got a business sale situated in the UK, and for a service provision change, you need that organised grouping of employees in Great Britain. But where the business or most likely services are being transferred out of the UK, you can have a situation where TUPE still applies, but it's going to be very unlikely that you would actually have that practical transfer of employees to outside of the UK. And in those situations, in essence, you end up facing a redundancy situation. But it does need a lot of consideration about how to deal with that properly and manage all the risks that can arise.
Okay, thank you. Jane, I'll ask you, well, I'll combine two questions we've had on this, on a similar topic, which is about second generation outsourcing. So would TUPE apply, i.e. would there be a second generation outsourcing when the original procurement was not an outsourcing in itself, but it was because the customer had to obtain services that they didn't have or couldn't perform in-house?
So TUPE can apply in an outsourcing situation, whether it's the customer no longer doing what it did in-house and contracting it out. So that's a first generation outsourcing. It can apply where that customer decides to change service providers. That's a second generation outsourcing. And it can apply if the customer decides to bring those services back in-house. That could also be TUPE. What won't be TUPE, perhaps I'm understanding, hopefully I'm understanding the question right. What won't be TUPE is if the customer decides to procure something neither it does nor another service provider does for it already. So a completely fresh set of services. That then TUPE doesn't apply because there's nothing to transfer. It's completely new, starting from scratch. And
then if there is a change of that provision further down the line, so there's a new provider of that service, that's when we can start seeing TUPE applying at that stage. Yeah, so that would be what we would call a second generation outsourcing. So there's an existing provider in place, and provided all the other factors that you need for TUPE transfer, so fundamentally the same services, etc. As long as that's the case, then if a new provider comes in, then TUPE can apply. Okay, thanks. Hannah, just looking at the subcontractor issue again. So they are the service provider and they subcontract some of the services or all of the services to one of their own subcontractors. So at the end of the contract, if the contract's lost, so there's a new provider coming in, what happens to those people working at the subcontractor, especially if there's a group of workers that spend most of their time supporting that customer?
Well, TUPE specifically says in a service provision change that it's also going to include subcontractors of service providers. So provided the subcontractor there's been a flow through of the services from the first tier supplier down to the subcontractor, and the subcontractor is continuing to provide the services for the ultimate client, then TUPE can apply if you've got that organised grouping of employees and you've got workers or employees who are assigned to that organised grouping. So the transfer then would go from the subcontractor to the incoming provider of services, and that could be a supplier at either who's directly engaged by the client, or it could be a step down. If the supplier themselves decides to change who it's using as a subcontractor, then there would be a TUPE transfer across from subcontractor to subcontractor. So yes, we do need to consider subcontractors, absolutely, and it's important to consider how those services have been flowed down.
Okay, I think we'll wrap up with a few questions about ELI, because there's always a bit tricky, particularly when you start considering data protection. And we've had several questions on this topic. So perhaps Jane, I'll summarise them for you and you can provide the answer, hopefully. My summary will make sense. So the first point is, if you send the ELI, which is employee liability information, earlier than the 28 days, do you need to anonymise it? Secondly, how does it work with consent of the employees? Do you need the consent of the employees? And I think the last question, probably that we've got time for, is does the transferee actually have to request the ELI in writing, or do they just have to provide it?
Yeah, okay. So in terms of the first one, if you're not within the 28 days and therefore you're not within the complying with the statutory obligation under TUPE, then you do need to be very mindful of your GDPR data protection obligations, and we would recommend anonymizing, pseudonymizing that information, because you're going to need to have a, if you were not going to do that, you would need to have a reason to rely on, and it's difficult to see what it would be. You can't rely, save in very, very specific sets of circumstances, on consent in an employment context to allow data to be shared, because of the inequality of the bargaining position between employees and employers. So consent isn't going to help you in this situation. If you were going to share it before 28 days, you would need some other GDPR protection exemption to rely on, and it's generally much safer to do it on an anonymized basis, because that exemption is hard to find. The transferee doesn't have to request it. The transferor, it's an obligation that's fairly and squarely on them under TUPE, so they have to take the initiative to provide it. Of course, in practice sometimes it is asked for, but the transferee doesn't have to ask for it to get it.
And the transferee may want extra information over and above the ELI, of course, as well. Thank you. I think we will have to call it a day at this point. Thank you for everyone who's submitted their questions. We hope you found the session useful. We've not managed to reach everybody's questions, but if we haven't reached your question, we will get in contact after the webinar. The webinar will be on the website shortly. And I just want to flag a couple of housekeeping points. Please, if you would have time to fill in the feedback questionnaire, we would find that really valuable to help us plan for future sessions. And what we've got coming down the track so far is in June, we have a session on public sector and TUPE. So if that's something you or your colleagues are interested in, watch out for the invite for that. And then in autumn, about November, we're going to have a session on pensions and TUPE, and that's always a really particularly interesting topic and difficult topic, and one that we get a lot of people wanting to hear about. So please watch out for that as well. So thanks again, and please get in touch with us if you've got any more queries.